Good morning, friends. A fantastic judgment by Kerala High Court, which elaborately discuss about what all are the grounds the registrar can refuse to register any document, under what circumstances they may hold an inquiry, and when they have no right to refuse registration of any document. A very fantastic judgment discussing about Registration Act 1908. This is AR 2025 Kerala 44. AR 2025 Kerala 44. Mohammed Kutti versus Sub-Registrar Palakkad. So when settlement deed was presented, the registrar refused to register it, stating that parental documents were not produced. Therefore, they have refused. So, the learned judge, respectable learned judge, has categorically stated at paragraph 4 under what circumstances, in pursuance of Registration Act 1908 and Registration Rules Kerala, framed under section 69(2), if it is in Tamil Nadu, it should be Registration Rules of Tamil Nadu under section 69(2) of the Central Act. See, these all are the reasons when the registrar can refuse for registration. Number that the document is written in language not known to registering authority unless a translation copy is filed. Unattested interlineations, alteration, corrections, and that was not attested. Then the property description was insufficiently stated. Then the document which ought to have been accompanied by a copy or copies of map or plan, then date of execution is not properly mentioned. Then the document was not timely presented, and it was not presented by person who ought to have presented it. There was no passport size photograph of impression or thumb impressions. Therefore, we can refuse. Then, if there were some grounds for presentation delay, if it is not accompanied with that, then if he is not satisfied with the identity of the person who is appearing before him and claiming that he executed the document, and he is not satisfied as to the right of a person appearing as a representative, assign or agent to appear, then execution is denied by any person. If any, this is most important, when registering authority purposely the registration was delayed purposibly for a prescribed time, registrar may refuse to register it for non-appearance, being treated as tantamount to denial of execution. Then question of minor, idiot and lunatic. Then there should be a commission should be appointed under section 30 of the Act about their eligibility or consent, whatever it may be, to that whether they are eligible for qualification or disqualification. Then the execution is denied by the representative of a deceased person upon whose property is derived. If suppose some of the representative admitted, some of them refused to admit, then they may let to apply for inquiry into the fact of execution. Alleged death of the person by whom documents purport to have been executed has not been proved. The registering authority is not satisfied as to the fact of execution in case of will or an authority to adopt presented after death of testator or donor. Prescribed fee or fine not been paid. Full address of all persons of executing and documents are not given. A quantum demise or a renewal thereof shall be refused to registration if does not contain the following particular: name of particulars, description of the holding, the government tax payable on each of them, and renewal fee if not paid, then settlement patta, Michivaram, Janmavaram, and the Janmavaram respective land, each of several parcels land comprised in the holding. All these things are the grounds upon which the registrar can refuse or delay and hold an inquiry. But as per section rule 191 and 67, the registrar was not empowered to insist for the original title or to produce the document. Therefore, the order of SRO was set aside and directed for registration. Document to be produced in proper format. If the settlement deed is in proper format, you have to register it. This is the ratio. And go through the judgment, keep this judgment on file and record permanently at instance purpose whenever you enter into the premises of registration authority. Best wishes.